Hello, I'm Andrzej Bujalski KC, a senior barrister at 36 Group in London. I specialise in financial disputes arising after relationships break down. This is part 4 of our 6-part series of videos providing a basic introduction to English law to lawyers outside of England. We're going to now look at asset protection. Sometimes you'll have a client who has assets in England and Wales which need to be protected while a divorce is proceeding in the country where you practice. If there is a concern that the other party might dispose of or otherwise dissipate assets which are in England, it may be possible to obtain an injunction to prevent that from happening. That might be possible even where there are no family proceedings going on in England. The English courts will, when appropriate, grant an order in the form of an injunction to protect assets to assist the proceedings which are taking place in another country. Injunctions can be used to protect things such as bank accounts, investment funds and pensions very effectively, because once the court has made the order can be served on the bank or the fund managers in London or wherever they're based in England, and the order will prevent them from doing anything which would breach the order. Protection of assets will usually be by way of an injunction which prevents someone from doing something before they've had a chance to do it. Sometimes it is too late to prevent it and the party's already taken steps to dispose of an asset. If so, the court may be able to set aside that transaction, such as the sale of a property for less than it's worth or simply a transfer to another family member or to an associate, if it finds it was done in order to avoid the claims in divorce. The courts can also use the power to issue injunctions to stop somebody leaving the jurisdiction, or by requiring them to surrender their passport until they comply with the court's orders or any other conditions that have been imposed. That can be a very useful power to gain compliance with orders of the court. The power to issue injunctions applies not only in divorce but also in some of the other types of proceedings we've discussed in other parts of this webinar, such as Part 3 claims that was discussed in Part 3 of the webinar series. When it comes to enforcement of English and Welsh orders within England and Wales itself, the courts have very extensive powers to do so. The powers of enforcement of English orders in England can often be used to enforce orders made in other countries too. There's a very useful procedure under Rule 33.3 of the Family Procedure Rules 2010, which you commence by issuing a form called a Form D50K, which brings the case before the court, requires the party who's in breach of the order to answer questions from the court and questions from any cross-examining lawyer representing the client who's trying to enforce the order. And at the end of that process, the court can make any of the enforcement orders which are available to it, including injunction orders. Committal proceedings can be brought for some breaches of an order. A committal order means that a person in breach of an order can be sent to prison for the breach, although they are usually given a last chance to comply with the order before they are actually sent to prison. Sometimes an overseas financial order after divorce can be enforced by the use of the Part 3 jurisdiction, which Paul Infield has talked about in Part 3. For example, in order to deal with a property in England or to divide a UK-based pension scheme. When you are seeking to enforce an order made in your jurisdiction in the English courts, we as English lawyers refer to it as inward enforcement of an order. When confronted with that sort of situation, we and the court would need to consider a number of questions. For example, first, in which country was the order made? Different treaties apply and different conventions apply in relation to different jurisdictions. Some examples are the Hague Convention on Maintenance Enforcement in 2007, the EU Maintenance Regulation, the Maintenance Orders Reciprocal Enforcement Act 1972, the Foreign Judgments Act, Reciprocal Enforcement Act 1933, as well as a couple of more obscure provisions from the 1920s. There's also a number of bilateral agreements that exist between the UK and other countries. It's fairly obvious even from that very brief summary that these things can get quite complicated. Second, we need to consider what the nature of the relationship between the parties was. Was it marriage, or was it civil partnership, or was it something other than that? That will affect the options that are available to the court and the orders that the court can use. For example, the Part 3 jurisdiction that we've talked about can only be used where there's been a divorce following a marriage. Next, what was the order for? Was it for maintenance or was it for capital orders over property? Was it based on meeting needs, or was it for a sharing of the assets? Was it a fixed figure, or was it a variable order? These are all questions which will apply to orders that are made, particularly those that were made whilst the UK was still a member of the European Union, because of the way the maintenance regulation limits the court's jurisdiction for those types of orders. Was the order an interim order or a final order? That will also be relevant to enforcement. Unfortunately, because this is really quite a complicated area, there's clearly going to be a need for specific and expert advice in each case due to this patchwork of provisions that exists. Still talking about inward enforcement of orders, the Hague Convention of 2007 on the enforcement of maintenance obligations is a very helpful and powerful provision, but again, it's not entirely free of complexity. There are many signatories to it. Some are signatories with some reservations as to what they've signed up to. If you are in a jurisdiction which is a signatory, you're probably already familiar with the provisions and may well have used them. And if your country isn't a signatory, it probably won't help your client in any event. In very brief summary, the Convention deals with maintenance arising out of parent-child relationships and in relation to spousal maintenance. Maintenance in this context doesn't include capital division orders. It does allow enforcement of maintenance settlements and agreements which are concluded before a judicial body, but often not more informal arrangements. Where it applies, it requires the courts of the contracting state involved to give recognition to the order and to enforce the order without usually being able to interfere with the order that was made. There are very clear rules within the Convention to prevent competing proceedings taking place and subverting orders that have been made by a competent court. It provides a very clear role for central authorities, particularly when it comes to the enforcement of child maintenance orders. But as ever with international cases, if you are going to be using the Convention, local advice in England is really very important and in many cases pretty much essential. You can contact us for that kind of advice. Although the UK is no longer a member of the European Union, there is still some ongoing relevance from the EU maintenance regulation when it comes to orders or proceedings that commenced prior to the UK leaving the EU on the 31st of December 2020. As already mentioned, there are some particular bilateral arrangements that exist between certain states. Your own government should be able to advise you if your country has such an arrangement with the UK, and you can then see if it can be applied. But again, local advice here might well be useful in order to properly get a sense of what can be done and what arrangements can be made in the UK for you. There are various rules on reciprocal enforcement which are set out in the Family Procedure Rules at Part 34. I'm not going to take you through those today because they're well outside the scope of this particular webinar. When it comes to enforcement, we would really very strongly stress the importance of seeking local advice from specialist lawyers in the jurisdiction of England where you're seeking to enforce, even if you're seeking to enforce through the central authorities. We at 36 Family are very well placed to give you that sort of advice if required. In the next part of this webinar, we will consider how family law in England and Wales deals with disputes over children and their care and welfare, and my colleague Joe Ecob will guide you through some of the aspects of that area of the law.